Hey.
Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2019-2524 DP, Carrie Yarbrough versus Ryan Van Beck.
This matter is before the court on the plaintiff's objection to the referee recommendation. Ms. Yarbrough, you attached substantial amount of material to your objection, but I will state under the applicable court rule, it's MCR 3.215 parens E parens 4 requires that an objection must be clear and concise statement of the specific findings or application of the law to which you object. And if there are any inaccuracies, you have to state with specificity the inaccuracy or omission. And after reading your objection, quite frankly, I have no idea what you're objecting to.
Did you get the transcripts? Were you able to review those?
I was not. I was not notified that those came in until this morning. I have tons of motions scheduled, so I wasn't able to review the transcripts. But again, I'm asking you, you just can't object because you don't like the results of the referee recommendation. You have to state what factual or legal error that the referee made.
Yeah, so I just am objecting to the fact that Ryan doesn't have an established relationship with my son yet. And I just think that overnights are premature. I would compromise to day visits supervised with Family Children Services so that their relationship can be documented. And then I would be willing to review in 3 months.
Okay. Mr. Van Beck, what's your response?
No, I don't agree. I think supervised visits with my mom is fine. She trusts my mom having him, so I don't see the problem with supervised visits at my mom's house.
Okay.
Okay.
And I don't know specifically what the referee is that in the referee recommendation, Mr. Van Beck?
Yes, sir.
Okay. Well, what's the problem then, Ms. Yarbrough?
I just don't feel that his mom, I want it to be a third party impartial person to supervise these visits.
Okay.
I'd like to have it documented how their relationship is building and growing.
Okay. Well, unfortunately, there may be a lot of things that you want, but in this particular matter, the referee has heard the evidence and made a decision based upon hearing that evidence. You have not, in fact, stated with any specificity any factual or legal error that the referee made. As a result, the court simply can't set aside the referee order just because that's what you want, without, again, complying with the court rules. So based upon that, what the court is going to do is the court is going to deny your objection at this particular time. So that order will remain in place. And the court will end this matter at 10:27 a.m. You're free to go. Have a good day.
Can I say one more thing, Judge?
Okay, you can if you want,
sorry.
but I denied her objection, so.
Okay, just one thing we can't agree on is pickup and drop off. There's nothing about pickup and drop off in the order.
Well, it states times, doesn't it, in the order?
It states times, but nothing about picking them up or who drops off or picks them up, and we can't agree on that.
Okay, and are you both residing locally?
Yes.
Yes.
Well, if you're residing locally, then the party that is exercising parenting time is the one to pick up and drop off.
Okay. Okay.
That's standard procedure unless it's stated otherwise in the order.
Okay. Thank you.
Okay. Thank you.
Yeah.
Have a good day.
Thank you.
Have a good day.
Motion and not a motion.
Look at
Should
the
I prepare an
hate
order?
on that face.
Calling case 2023-685 DM Dylan Hall versus Emily Hall.
Good morning to both of you. This matter is before the court on the defendant's motion for custody. Ms. Hall, I note you've stated in your motion what you want. However, the court will note that there was a judgment of divorce entered just weeks ago on September 27, 2023. You have to show a factual or legal basis for modifying that judgment since the entry of the judgment. So what is it? What is your basis for modification or changing that custody?
So, Your Honor, back when I accidentally missed a court date because I misplaced the court paperwork. So that's totally my fault. So I wasn't able to give my side of why I should have our kids.
Okay. Let me tell you how this works. I don't want to cut you off, but you're going to get into a lot. What happens when you are modifying custody? The law states that you can only go back to the date of the last order. So you would have to establish a basis for modification from the September 27, 2023 judgment through the current date. You can't go back and say something happened 6 months ago, a year ago, or whatever, because that order resolved and, if you would, consumed all of those particular issues at that time.
Okay, so I have to, I guess I don't understand. There's no legal reason she can't be with me, so I just don't know what else I can do, because she's supposed to be living with me. Dylan and I discussed before we even got divorced that's
okay.
How we wanted.
Ma'am, none of that matters. The judgment.
I know, I understand.
Okay, so it's from the date of the judgment of divorce forward.
Apparently,
what is the basis for modification of that?
Dylan lied on the paperwork and said that she was in school, and she wasn't over there. She was enrolled in school over in Battle Creek, where I live, with me.
Okay.
And he also lied about not having a job, and that's why my child support is so high. And also because he claims that she's in daycare, when I honestly don't know if she is or not. Last I knew, she was getting babysat by his sister-in-law because she just had a baby, so they're staying home. So I'm paying $300 a month for childcare that I don't think that she's going to.
Okay. What you can do is you can file a motion for modification of the judgment of divorce. Set forth your factual basis. For instance, if it says, if you're supposed to pay childcare and there's no childcare, you can set forth that basis that he's not incurring any childcare and you're being charged childcare. So it'd be anything that would be again a factual or legal basis for modification of the judgment.
Right, and that's what I don't know. I'm supposed to get proof of that and show you. I don't. You have to have that, because if you set forth your factual and legal basis, he said, okay, he's not incurring any child care. Well, his answer to the motion would be, yes, I am. Here's the person. We get something. He never showed proof of any of that.
Well, that's because you didn't contest the judgment at that time, and as a result, he doesn't have to. He doesn't establish and provide proof when there's no objection to it.
He's lying about everything now. He's had a job the entire time, and he's claiming.
You can always bring that up in your motion to modify child support as well.
I did. Isn't this what I filled out? I'm confused on what I filled out, because that's what I went down to a friend of the court and I said, this is what's going on. Can you look into my case? And this is what they handed me for the paperwork that I needed to do.
Okay. Your motion is a motion for custody. Okay.
Okay.
That's what you filed. And so that's what we're addressing. Hold on. I'm looking at your motion. I just brought it up. It says motion regarding custody. So that's what's before the court. If you want to address other issues, you'll have to file a motion and provide in your motion that these are the items that you're requesting, the factual basis or legal basis why, and then include what they call an addendum clause, which is your prayer for relief stating what you want. The only thing I have is a motion for custody. So if you file the appropriate and proper pleadings, and the court will address those at those times, because you have to give the other side notice as to what they're going to have to defend. And if you file a motion for custody, but then you're talking about parenting time and you're talking about child support and all that, it doesn't provide them with notice of what you're requesting.
Well, my request is that she comes and lives with me, so that
I
just it'll
understand that.
figure child support
I understand
out.
that, and you've not set forth a basis that the court can look at to make a determination from the September 27th, 2000.
Because I want her to. That's
Well,
why. She should have never been taken from me in the first place. He took her on false accusations.
Okay, just because you want something doesn't mean legally the court can do that. Okay? So what the court is going to do is I am going to deny your motion because you've not set forth a factual or a legal basis for the court to modify the judgment of divorce at this particular time.
My daughter wants to come live with me. Her dad is keeping both of them from me.
Mr. Hall, is there anything else that you have to add in this particular matter?
Yes, I do. Actually, I've got the proof of her being in
Sir,
childcare.
hold on. I've denied the motion, so you won the motion. So do you want to argue about winning the motion?
No, if I won,
Okay.
then that's
Okay.
fine.
The rest, if she files another motion addressing all of those other issues she's brought up today, then you have a right to file an answer and again, to refute anything that she states, okay?
Yes, thank you.
Okay, thank you. The court will end this matter at 10:37 a.m. You're free to go. Have a good day.
This is Attorney Leif Midgorden, P84755.
No, just give me your last name again.
Midgorden, MIDGORDEN.
Okay, McGordon. Okay, thank you.
Calling case 2023-948 DC, Penny Hickman versus Gabriella Lubo.
Court will note the appearance of Mr. McGordon in this matter on behalf of the plaintiff. This matter is before the court on the defendant's motion to set aside default. Ms. LeBeau, you can proceed.
I have wrote a good, good morning, Your Honor, first of all. And I have wrote a good reason in my motion to set aside default.
Okay, well, what happened, let me tell you, people will always say, well, I've got these reasons. You have to show proper cause to do that. So it's not just that I have a reason, it's proper cause under the court rules to set aside the default.
So I have to show proof?
You have to establish proper cause as set forth in the court rules for setting it aside.
Well, the only cause I have is what I wrote in the order. Should I state that?
Yes.
Okay, so I was having a mental health issue at the time, Your Honor, and I just wasn't in a mental state to answer anything. I had a mental breakdown. I had to go see a therapist. I wasn't able to do anything.
Okay.
I was severely depressed. I literally had to go to therapy for like weeks straight. And when I finally got right, I decided, let me check on this. And by the time I checked on it, it was in default.
Okay. Court will note that a default was entered back on July 13, 2023. Mr. McGordon, what's your response?
Yes, Your Honor. My first response is, as the court just indicated on the record, the motion to set aside default, given that the default was entered July 13th. If the default is entered July 13th, that motion to set aside default was not filed within 21 days of that entry of that order. And furthermore, as this court has indicated on the record just now, under MCR 3.210B3, the defendant unfortunately has not provided any good cause under that rule to set aside a default motion. She has not even alleged a substantial defect or irregularity in the proceedings. nor has she alleged that there was a reasonable excuse for failure to respond in any of this case. It's just that she had a mental breakdown. Like, it's not like she was hospitalized and missed a proceeding. It's just that she had a mental health crisis and didn't respond in a case filed in April. We're now in October. There's never been an answer filed. I don't believe either of anything alleged in the letter that was written to the court clears the threshold of good cause under MCR 3.210B3. I know that rule has been modified, but there was never a meritorious defense offered to this court either in that motion to set aside default. So the plaintiff would ask that the default remain in place, and that if defendant disagrees with that default order, she should need to file a motion to change custody and needs to prove a proper cause or change of circumstances as to why custody should be changed from that default order under Vidvarka, Your Honor.
Okay, thank you. Anything else, Ms. LeBeau?
Well, Your Honor, the only thing I want, like, I don't mind if Ms. Hickman has like serenity. The only thing I would want is the parenting time. Like, Ms. Hickman, Serenity is able to, which is my daughter, is able to go to school out there through high school. I don't mind that. And I just want the parenting time revised. I don't mind paying the child support. I don't mind any of that. I just need the parenting time revised.
Okay.
That's all I
Well, you
need.
always have a right, ma'am. You always have a right to seek a modification of parenting time. And again, what you'll have to do, you'll have to file a motion for modification of parenting time, providing a factual basis for doing so. And then the court will entertain that at that particular time.
Okay. How do I, when it comes to, like, if me and Ms. Hickman were able to agree on something with the court, we were able to agree on something and get it documented, would that be all right with you? Would I be able to submit that in? I believe we can agree on something, since Ms. Hickman does want my daughter.
If you can agree upon something, the court can modify the order or judgment based upon that agreement. So that's up to you and up to the two of you. But at this time, the court will deny your motion to set aside the default. The court does not find that there is good cause under the court rule for the granting of the motion.
So what I have to do next is put in a modified parenting time.
You'd have to come to an agreement, or you would have to file another motion, a different motion.
Okay, do I contact her lawyer or do I contact Ms. Hickman?
That's up to you.
Because I don't have any of I didn't even know when I had called to, do the certification mail, there wasn't a lawyer on present, so I don't know his information to contact him.
His information would be on the pleadings in the court file, so.
Okay, so I would just have to call the clerk's office to get it.
All the clerks get that information, and then you can contact Mr. McGordon.
Mr. McGordon, I'll contact you regarding parenting time, if that's okay with you.
Mr. McGordon, you can prepare the order denying the motion, submit under 7-day notice of entry.
Yes, Your Honor. I will
Okay.
more than happily do
Thank
so.
you.
Thank you.
Thank you for coming out. Much love.